Welcome. Today, we have Sean Clemmensen. He is the attorney at Tiago Title. Good morning, Sean. Thanks for being here.
Good morning, Jamuna. Thanks for having me. It's always good to see you guys.
Short notice, but thank you. We're going to try and talk about some important things going on here. On the game, I guess, these are questions that, are, I'm sure, in everyone's mind, especially agents. And we want to just kind of address the elephant in the room, I guess,
Yeah, I think it's important to do. I mean, part of why I've spoken about it so much is just to try to ease people's fears a little bit about it, but also give them a little bit of dose of reality too. So
I guess let me just dive right into it and ask you the very first question. Why did NAR, National Association of Realtors, enter into the settlement that everyone is aware of?
Honestly, I mean, the idea from NAR was it for realtors protection. It was, I think, the idea that if you can get ahead of this and resolve this, then the sooner the better, and agents can and realtors can get back to doing what they do best. I think the legal team at NAR knew that the litigation was not going to stop on a number of levels and a number of states as it's continued to do, and so I think it was a good thing to try to fend this off. And to be candid, I'm not sure that, and I don't know the budget of NAR, but I'm not sure that it could have afforded to handle lawsuits and litigation on a number of fronts throughout 50 states, to be honest.
I think they did the best they could.
I think they did too. I wholeheartedly believe that.
Yes, and hopefully to continue. I think their main goal was to continue to make sure they took care of their members, right, and preserve the choices that consumers have. Their real estate services, they've always had a choice, So I think it was the best thing that they could do, given what they have.
They've always had consumers have always had a choice, and I think that was, and NAR's always focused on the consumer and wanted that to be clear here too, that this isn't just about realtors, it's about the consumer as well. And I think that was a very educated decision to enter into this settlement that hopefully gets approved.
Right. Hopefully it gets approved. Yes, we're all waiting. And let me just add so that our listeners know, when we talk about NAR or NAR, we are referring to the National Association of Realtors. So another question for you, and that is, who exactly is covered by the settlement?
Yeah, so obviously anybody that's a part of NAR, anybody that's any MLSs or that are wholly owned by realtor associations, state associations that are affiliated with NAR, they all benefit from the settlement. Obviously, if you're not a member of NAR and you don't use the term realtor, then it doesn't apply to you.
I guess that takes us straight to the next question. How does the settlement affect, the state and territorial and local associations?
That is an excellent question, and one that I've spoken about at length, because as an attorney, you have the federal level, which is really where NAR is, and then you've got obviously 50 other states. And what does that settlement look like? And how does it impact every single association across every single state? And the truth is, we don't really know right now. We don't know what it's going to do. What we've already started to see is that different states, through their different associations, similar to the Texas Realtors, are already incorporating changes into their forms. They are meeting, they're talking about it, they're creating, groups, they're creating different organizations, subcommittees to address this very topic. So we don't really know how it's going to play out on a state level. Once you have a federal rule that's in place, or a federal lawsuit that comes into play, it does trickle down with each state, but the timing of that is up in the air. And even TXR, Texas Realtors, and the Texas Real Estate Commission, they're sort of taking this sort of backseat approach. They've created I don't know if you want to call it a forum or a group or sort of a panel, war panel type group that's addressing it and looking at it and monitoring it and seeing what happens. But they're taking a relative backseat approach, whereas like some states like California have already started implementing changes in their forms. That has not occurred in Texas yet. They're taking a little bit more of a backseat approach, which I honestly think, given the recent Department of Justice court ruling by the 3-judge panel, is not a bad decision by the Texas Realtors nor TREC.
Yeah, I guess, we're all waiting, but we're ready.
We're ready. We're all ready.
We're ready to act on it and make sure that, that we get ready to do some of those compliance changes and best practices, right?
Yep.
So I'm sure our members have this question: is CCAR covered under that settlement?
Well, I'm looking at Collin County Area Realtors. Then it is affiliated with NAR, so it would, in theory, be covered under that settlement. Yes, it would be. We will see what happens because some of the plaintiffs' attorneys in the Texas litigation have already come out and said, well, my plaintiffs aren't benefited by this settlement agreement, so I don't have any plans to dismiss the case. So we'll see what happens. It will be, I'm sure, some legal arguments made by the defense teams in the Texas litigation, but that's to be determined.
So can you kind of go over the key terms of the settlement?
Yeah, I mean, one of the probably the most important key term of the settlement is that there's no longer going to be offers of compensation included in the MLS. I mean, that is no more, or will be no more come end of July. That is gone, and I think one of the smart things that I think NAR did was get ahead of this. And so what they basically done is said, hey, this only applies to properties in the MLS. It does not apply to off-market properties, thus still giving the parties the opportunity to go freely contract, right? You buyer's rep agreements, which is another thing that NAR instituted. If you're going to have a property as part of the MLS, you have to have a buyer's representation agreement signed, which in my humble legal opinion, you should have been doing always as a buyer's broker, because there's nothing else that legally guarantees you get paid. So that's another rule change. That if you're going to put a property in the MLS, you have to have a buyer's representation agreement signed. You should have had that anyway. But those are really the two, I would say, most significant terms or details of the settlement, the 43-ish page settlement agreement.
Do you know when these practice changes need to be implemented or could go into effect?
Well, NAR has said mid-July. So mid to end July, these practice changes, the two main ones that we were just discussing, are supposed to go into effect. That's going to occur regardless, because that is a NAR policy change. That is going to happen irrespective of what is currently happening in the litigation. So, and NAR has already said that, whether somebody objects to the settlement or an entity objects to the settlement, doesn't really matter. We're going to institute these changes regardless, come mid to end July.
Yeah, I think that's what we're all targeting. Some of those changes in place and get some of our realtors out there and get them educated. Once again, it's all about the education right now.
Got it.
That's what we're trying to push.
Yeah, I love it.
So kind of talk to us about, how some of these changes are basically going to affect the daily practice of a real estate agent moving forward.
Yeah, I mean, great question. I think in my response to that normally is it really shouldn't have changed a whole lot of what you're doing anyway. And what I mean by that is, I've already said one aspect of this is that on the buy side, you should have always been getting buyer's rep agreements signed regardless, because that's how you have a contract as the broker and the buyer to guarantee that you get paid. So that should have been part of your procedure regardless. And I think another practical side of this is that you got a full communication, effective communication, in communicating your value, right? I mean, we get lost is both as agents or attorneys or anybody in a profession. We sometimes forget to communicate our value to our client or our prospective client. And so what this does is really force agents that weren't doing it already to communicate that value. Why are you worth whatever percentage you agree to? So I think it's really important for agents to incorporate that, if they weren't already doing it, as part of their discussion with their clients. And you're also going to have to now, one of the things that you will absolutely have to do as part of your practice is you're going to have discussions with the listing agent about how the compensation is going to be paid. Let's call it what it is. It is going to force agents to have more conversations with their clients. It's going to force agents to have more conversations with the listing broker. that will certainly increase. And I think it's really, really important for agents to do that. Treat this as though you treated it when it was an off-market property. There's really nothing different that's happening on an off-market property versus an MLS property now. Even a year ago, before this settlement came out, what we're talking about now, you were having to do on off-market properties anyway, right? Or commercial properties anyway. So it's just implementing that practice on a regular basis now, more so than ever, on properties that are in the MLS. You just can't stress that importance enough.
I think communication is going to be critical, right? To have this discussion with the client that you're working with up front.
Yeah, exactly. Up front, not 2 months later. That's not going to work.
No, great. I mean, we have great agents out there who do a great job, serving their clients. And, sometimes it's so hard. We just go do what we do and we do it well. And trying to explain your value proposition is always difficult. We're definitely worth, our value, but
for sure, articulate
that. It into work.
And that's where practice comes in. I mean, and I sort of equate it to, me myself as a real estate attorney or a corporate attorney. Every call I take for a prospective client, I have to demonstrate my value to them. And at first, 15 years ago, when I became an attorney, it was kind of uncomfortable because it came off as arrogant. It came off as too confident. Oh my God, am I going to push them away? But then I realized over the years that it's not arrogant or it's confidence, and it's just stating facts. This is what I'm worth. If you don't believe I'm worth that, then it's okay if you want to go pick somebody else. That's fine with me. But I think I agree with you 1,000%. Agents are worth their weight in gold. I would pay an agent God knows how much percentage because I don't want to deal with what you guys have to deal with every single day. And so if you can demonstrate that well and articulate it well, I don't think it's going to impact commissions as much as people think it's going to be, or at least the media, with all due respect, is talking about.
Value propositions, once again, I think once you see it written down and you write down what your value proposition is, and you repeat it and say it to yourself. Say it, repeat it, get your script together and say it. And I think you'll be fine. We just have to articulate it. The consumers always had a choice. That's why they go out there and interview different agents, right? So they've always had that choice. But I just wanted to say that I have just spent literally 3 months with a client. So he was referred to me, and we managed to get this contract that we've been working with on, for a whole month. Mm-hmm. I have a hard time bragging about myself, but
don't be afraid to do it. Don't be afraid to do it.
Absolutely. Don't be afraid to do it. And, and the fact that this client every single day has told me, oh my gosh, I'm so glad I found you. You have helped me work through this deal. It was a very complicated deal. And I have to share this because I think it's really important. And this is what my client told me yesterday after it was all done. He was happy. He was really happy. And so he says to me, my gosh, you are amazing. And this was after we wrote the final amendment. He says, you are amazing. I am so impressed with your work ethic and dedication. Way to go.
Love it.
To hear that, right?
Yeah. But that's exactly what you're talking about, the value proposition. And it's okay to give examples to clients too, just like you did, right? I mean, a new prospective client using that type of example is an excellent way to show that, hey, I'm worth it without coming off as arrogant or, putting off somebody. So
yes, absolutely. We're doing what we're supposed to do.
That's it.
For us to serve our clients and keep their best interest at the forefront always. Just do the right thing. And you hear that all the time. Just continue to do the right thing. So that's great. So let's move on to the next question. So I guess, members will probably have this in their mind. What is Texas Realtors and TREC, which is a Texas Real Estate Commission that serves the public? What are they doing to prepare for these changes that are coming?
Yeah, a good question. And I've got some friends and people I know over there, sort of in the inner circle, for lack of a better word, phrase. that they are taking a backseat approach right now. And it is sort of a let's wait and see. Now, they have created a task force to monitor this. The task force is actively involved in not just monitoring the federal level, but checking other states, seeing what happens, seeing what forms are being done. I believe, and a lot of the folks believe that they will take some sort of action, but there is a backseat approach because the Department of Justice, I believe, is going to intervene in this NAR litigation, and that will impact what type of steps a trade association is going to take. So I believe that that's why they are taking a backseat approach, because there is a lot of uncertainty still. That's the one key thing to remember. Still a lot of uncertainty to this entire process. All of us want it to be done now, but unfortunately, it just doesn't work that way. But they are monitoring it through a task force. The TXR, I'm sure, at some point will suggest forms changes that change its own forms. The broker lawyer committee, I'm sure, will convene and suggest changes because I can already tell you now there are going to have to be changes to some promulgated forms that are reflective of commission. I do think that will happen. I just don't know when.
And just so that we can clarify that, what is the definition of a promulgated form?
Promulgated form is a form set forth and put out there by the Texas Real Estate Commission. So TREC, the Texas Real Estate Commission, will promulgate forms or create forms that goes through the broker lawyer committee process. There's back and forth comments made to the comment period given to the public. The public makes comments, and then back and forth, and then a form is adopted or promulgated. Conversely, you have the Texas Realtors, which, as you guys know, is a trade association that creates its own forms, the buyer's representation agreement and the listing agreement. So we'll see. I do think there will have to be changes to those forms, and there will also have to be changes to some of the promulgated forms, in particular, page 10 of the 1-4 contract, where it has a few sentences about listing broker shall pay other brokers. So that'll probably change too. But we just have to be patient for now.
Mm-hmm. Yeah, absolutely. And these are the forms that, licensed realtors use every day. We're talking about, having the knowledge to know which forms to use, which are the right ones to use. They're different for each transaction, but I believe we have over 100, almost 200 forms that we have. A lot of them. And disclosures, they're written by attorneys and they're written to check both parties. So there you go. So moving on to the next question, and that is, how would the prohibition of offers of compensation on the MLS affect pending transactions that are going on right now, the current deals?
Yeah, well, good, great question. A little bit of unknown there too, because as it stands right now, there has been no rule change, right? So let's assume that it'll be mid-July that a change occurs in the policies of NAR. And that there are pending properties. There are going to have to be, we don't really know what's going to happen. Now, the contract is going to be binding between the parties. I would assume that a property that is under contract before the policy change, that offer of compensation, in my opinion, it was a unilateral offer of compensation, is still going to be valid. But I do think there's going to have to be a discussion, or there should be a discussion between brokerages and the sellers and the parties as to the commission. I would suspect that, and if I was advising brokers, which I do, that you would want some sort of ratification or confirmation of that commission that's being paid, get a separate agreement, even though I do believe strongly that a contract that's executed before the change, the compensation, offers compensation, is going to be enforceable. But you would want some sort of other written document, some sort of ratification in writing from the parties to the transaction and the brokers. That the commission is going to be paid out in accordance with whatever it was in the offer of compensation. So
here's a member question for you. So, we deal with contracts, it's a contract, it's enforceable. We don't deal with verbal agreements. They're not enforceable. So I guess the question is, since the listing prices and verbal agreements are not enforceable, will shared compensation only be confirmed in a fully executed contract? And does that mean that the price and compensation will be confirmed only at that point? So this is a member question.
Well, that's a good one, and I'm gonna break that down a little bit because it's going to depend on who's paying the compensation, right? So if we're assuming that the listing broker is going to share in their commission with the selling broker on an off-market deal, for example, because remember that's not part of the MLS, you're going to have what you've always had to have, which is the registration agreement between brokers. Okay, that's an easy answer that I just gave you. Let's assume that the property's in the MLS and there are discussions that the seller is going to issue or give a seller credit in exchange or for a portion of or all of the commission. Then that absolutely has to be in the contract between the seller and the buyer, right? Because the contract itself is only enforceable between the seller and the buyer. So we're going to have to put in there an area for the seller credit or the payment of the compensation. This is where I think there will be some sort of, or has to be some sort of promulgated form or tweak to the promulgated form, because Fannie and Freddie have come out, FHA have come out and said that a credit by a seller paying the buyer's agent's commission is not an IPC, or what we call an interested party contribution, right? So it doesn't count against your closing cost. Whereas if you look at paragraph 12 on the contract, that does count against your closing cost. So that's a long-winded way of saying if the seller's paying it, it's going to have to be in the contract somewhere. It's as simple as that, right?
So here's another member question for you. They want to know, will sub-agency and intermediary change?
I don't think so, because the Real Estate License Act of 1996, is pretty rock solid. And that's what banned dual agency, created intermediary effectively at the same time. So I don't expect sub-agency and intermediary. I don't think there's going to be any real change in the law in that regard. I really don't see why there would need to be. But no, I don't think so. But I will take that question one step further, which is that I believe that agents are going to have to be even more diligent than they were before on the agency intermediary, because of the fact that there is this increase and rise of, consumer awareness. And so particularly with an unrepresented party. So if you are an agent on one side and maybe the buyer is unrepresented, you're going to have to make it crystal clear to this buyer that you do not represent them, have your IABS form, and in every single communication, you almost want to be so repetitive that I am not your agent. You have the ability to hire one. I represent the seller only. So I think that's going to be really, really important for agents come this change to for sure communicate your representation to an unrepresented party and let them know that you don't represent them, because consumer awareness is on the rise. And along those lines, we may see an increase in the rise in the number of lawsuits against agents. So you just have to be careful.
It's back to education and really understanding what representation means, and to make sure that you understand who you're representing, and that, I don't know if I can bring that up, that dual agency is not legal here, at least in Texas, that I'm aware of. So yeah, they really need to come back to the table and get educated about representation. And NAR is also offering a free ABR, which is a buyer representation designation. It's been offered to its members. So I think it's a great time to take advantage of that. So moving on to the other big question here is that, the settlement involved $418 million. How will NAR fund the settlement?
If you look at their the flyers and guides that they put out, it's from the dues and the resources that they have right now, and that they will continue to obtain. So I think part of it, that not that number and the amount 4 years, it was really, that was arrived at what they calculate their dues probably to be and what they have so far in their tank, so to speak, and when they can pay it out. I'm curious, and I don't know the answer to this, as to whether or not insurance was involved for NAR. I don't believe it was, but that was something I was kind of curious about. But no, it's going to be funded from from the dues and the revenue that NAR has generated.
So yeah, that was one of the questions, does NAR's business insurance cover any portion of that settlement?
I would be surprised if it did, but I'm not an insurance coverage attorney, but I would be somewhat surprised if it did.
Mm-hmm. Okay. So here was another member question that I'd like to ask, and that is, they want to know, how was the $400 million settlement amount arrived at, and how will it be rewarded? And I guess they're thinking about how is that going to be rewarded to the buyers or the sellers that were involved.
The first part of that question, even according to NAR itself, was it's frankly the amount that they could afford to pay. And that's basically what they've said. NAR has said it's what we could afford to pay. How it's awarded and allocated, depending on the plaintiffs, remains to be seen. That is where the attorneys are going to be involved, and there's going to be very comprehensive discussions between the parties and the signatories to the settlement and other individuals throughout. We talked about the federal level and the state level and some of these other lawsuits throughout Texas, and whether that impacts, or not just Texas, the United States, and whether that impacts those or not. So that answer is TBD. We will see how those, in theory, in a settlement, it's allocated out evenly. And I would expect that to be the case here, but I don't know that for sure. That's all part of the negotiations.
So the next question takes me to how often are the settlements, such as NAR's, approved by the courts? What should members expect to see happen between now and the potential court approval?
Oh, man, the uncertainty continues. And on the federal level, and I can tell you this as somebody that practices in federal court, that will largely depend on whether or not there are objections that are asserted in the litigation itself to the settlement agreement. Are there interested parties that somehow intervene, which we'll probably talk about the DOJ in a second, but are there interested parties that intervene? Are there objections that are filed to the settlement agreement itself? Are there hearings on any objections that are filed to the settlement agreement itself? Oftentimes courts are reluctant to set aside a settlement agreement because in theory, it was freely contracted to and agreed to by the parties. So in theory, they really don't set those aside, but this is such a important conversation and an important topic that I do believe there will be entities or the DOJ will intervene or file objections, or at least a statement of interest, which could impact the approval of the settlement. It may involve revamping or revising or amending the settlement agreement if objections are made to satisfy those parties or those entities that objected to the settlement. So we shall see. For the most part, they're approved, but there may be some more revisions to the settlement agreement, which I expect to happen before it's approved by the court.
That brings us to our final question. How does the Department of Justice decision on April the 5th affect this settlement?
It impacts it. And it can impact it relatively significantly because, in just a brief history, for those that don't know, in 2020, NAR entered into a settlement agreement with the DOJ, Department of Justice. In 2021, the DOJ withdrew its settlement agreement with NAR. In 2023, a federal judge ruled in favor of NAR and stated that the settlement agreement shall remain valid and enforceable. And just recently, in March, a 3-judge panel decided to state that the DOJ could reopen its investigation into NAR, thus paving the way for the DOJ to intervene in the lawsuit with NAR. If that happens, when it happens, that will have an impact on the settlement because the DOJ, the antitrust division in particular, will probably have some say. They will swing their way around. The common thought, or the belief from a lot of us in the industry is that the DOJ does not like that the NAR settlement agreement does not address off-market deals, and that it sort of you've referred to it as a loophole. And if you read the Attorney General's statement following that ruling by the 3-judge panel, the Attorney General of the United States of America made it very clear that they want to reduce the overall cost to a consumer, and they believe commissions are a main culprit of that. Right? That was the Attorney General that said that. So It's pretty likely that the DOJ is going to shove its weight around a little bit. And if it does, that is one of those things that we may see a revision to the settlement agreement. I don't know that for sure. This is just my opinion and some others in the industry, that we do believe that there may be some sort of objection statement of interest filed, and thus a revision of the final settlement agreement. And if that occurs, it will be somewhat of a game changer, but it should change how you continue to proceed, which are still buyer's rep agreements, listing agreements, agreements with your consumer. It shouldn't change any of that. The same thing that you've been doing this entire time.
Okay, great. Thank you. What would you like to say to our Realtor members?
I'm truly proud of the members of CCAR. I mean, it is an incredible organization. And I would tell you that, like I've told many, many thousands of folks recently speaking about this, to not be afraid of the settlement. Don't let this settlement or this litigation cause you fear. Don't let it cause you to want to give up on real estate. Let it focus you. Let it motivate you to do better on the things that you are already doing, communicating with your client, value propositions, getting your agreements signed, all of these things that you've been doing so well. Let this motivate you to do it even better, right? Because at the end of the day, those that are part of CCAR, you constantly strive for education, and you're constantly striving to be better. And a filtering out some agents in the industry, or filtering out attorneys, or any profession, it isn't a bad thing. Right. So those that really take this serious, and those that devote the time to education and improving themselves, you're going to be the ones that come out on the better end of this. So I would just say, don't let it make you afraid. Let it motivate you, because at the end of the day, everything is going to be fine. Real estate agents aren't going away because there's such a huge value for real estate agents. And I think the profession is going to continue to be strong, and certainly here in Texas.
Wonderful. Thank you so much for that. We have a lot of work that we do on the back end, for advocacy, and we have to continue that important work, of advocating for our homeowners, and our property rights. And like I said, we want our agents to do what they do best, and that is taking care of their clients and serving them well, and continue with the education. So I wanted to say thank you so much, Sean, for being here. And lending your expertise and kind of clarifying some of these things that on our agents' minds, and a reassurance that, continue to do your work. You are a licensed profession, and you're a licensed professional. And so you've got, a lot of tools and resources, and we are here to support you as part of your association. And that's what we do best, and consider us to be your primary source of information and connection, and what I would like to say is that, as the president for this year, we want to go ahead and keep building for the future. And we have to realize that our clients need us. They may not always know that they do. But there are things that we know that will help them have a successful transaction, and help them, get into the property that they want, whether they want to buy, or they want to sell, or they want to invest. Get a good agent to help you. There are plenty of good agents out there. So just do what you have to do to interview them and understand the value proposition, and find the right match for you. So. Amen. Yes. Thank you so much. You have a great day.